Under the implied consent law, Vehicle Code Section 23612, a person who drives on California roads is deemed to have given consent to taking a chemical test if they've been lawfully arrested for driving under the influence of alcohol and/or drugs. If the driver refuses to take a breath or urine test, the driver is subject to both administrative penalties, like suspension of their license, and criminal penalties, like additional time in custody if they're convicted of driving under the influence. If the driver refuses to take a blood test, the driver is simply subject to administrative penalties. Now, while the implied consent law allows such penalties to be imposed, it doesn't permit officers to physically force drivers to submit to a warrantless chemical test, or to obtain submission by simply telling the drivers they must submit to the test without informing them of the consequences for refusing. In those circumstances, many courts have held that the submission of the driver will not be deemed voluntary, and consequently, the results of the test may be suppressed. It will also be a technical violation of Section 23612, which requires that the driver be told of the consequences of refusing a chemical test in a particular way in order for the license suspension based on refusal to be enforced. Now, over the past year, ever since the United States Supreme Court in Birchfield held that officers cannot rely on the implied consent law alone to justify a warrantless blood draw from someone who's lawfully arrested for driving under the influence, we've seen a significant number of cases where chemical test results have been suppressed. This video is being made to explain why is this happening, and to provide guidance on how to comply with the implied consent law, or at least avoid suppression of the chemical test results. Jim Leonard, the supervisor of Santa Clara County District Attorney's Office Misdemeanor Unit, which handles almost all the DUI cases in the county, will be the one explaining the problem and the solution. Jim will also be giving us advice on how to obtain chemical tests in Health and Safety Code Section 11550 cases. Jim, when someone has been lawfully arrested for driving under the influence of alcohol or drugs, what does Vehicle Code Section 23612 require officers to do?
The statute requires that the person shall be told that his failure to submit to the required chemical test will result in a fine, mandatory imprisonment if convicted of a DUI, and suspension of their license for 1 to 3 years, depending on their history of prior driving offenses. Even though the statute requires this warning be given, after the Birchfield decision, criminal penalties can no longer be imposed for refusing to provide a blood sample, but can still be imposed for refusing to provide a breath or urine sample. There is legislation pending to remove the criminal penalty language for blood draws from the statute.
Jim, when is it contemplated under the statute that the driver will be told of these consequences?
Before they give consent.
Jim, in your experience, do officers always read the full admonition before asking whether the driver is willing to submit to a chemical test?
No. Officers tend to handle this in different ways. Some paraphrase the admonition, others read the DUI admonition card created by the DA's office. While reading the full admonition is the safest practice, it's not necessary for a consensual blood draw.
Is simply telling someone that they must take a chemical test and then asking them whether they want to take a breath or a blood test some sort of problem?
Yes, this is a problem because under current law, this is considered involuntary or coerced consent because the suspect thinks he cannot refuse. Even though implied consent is part of California's vehicle code, the courts now treat situations where suspects submit after being told that they must provide a chemical sample pursuant to implied consent as involuntary.
Is that true, even if you say it nicely, like, you need to give a chemical sample, would you like to give blood or breath?
Yeah, that alone will be considered submission to your authority and involuntary consent because the suspect does not think he can refuse. Our appellate courts and other courts around California have repeatedly suppressed blood samples collected when the officer did not advise the suspect of the consequences of refusing to provide the sample and only told the suspect that a chemical sample was going to be collected. The court's reasoning is that by advising the suspect of the consequences of refusing, the suspect was therefore aware that he could refuse, and if the suspect agrees to give a chemical sample then, the suspect's consent can be considered voluntary.
So, If an officer tells someone that they must take a blood or breath test without advising them of any of the consequences for refusal, and the person then agrees to a blood test, will the results of that test be suppressed?
Yes, it's very likely.
Does the officer have to read the full admonition every time before asking for consent?
Evidence will likely not get suppressed if the suspect is informed generally of the consequences.
What do you mean when you say generally?
If the officer says to the suspect something like, to assess whether you are under the influence, you'll need to take a chemical test. Refusal to take any chemical test will result in the suspension of your license to drive for a period of 1 year or revocation for even longer period, depending on how many DUI-related prior convictions you have. And if you refuse a breath test, it can result in a fine or additional time if you're convicted of a DUI. Taking either a breath or a blood test will avoid any of those consequences, though, that I just told you about. Knowing that, do you want to take a chemical test? If the person refuses to take a test, you'll then still need to read the full admonition to the person.
Jim, even though that admonition has been truncated, it's still quite a mouthful. Is there any other alternative to doing it that way?
Yes, the implied consent admonition of Vehicle Code Section 23612 was developed largely for purposes of ensuring that the imposition of the consequences for a refusal could be imposed. However, in California, unless the Fourth Amendment actually requires suppression, evidence cannot be suppressed. The Fourth Amendment only requires that consent be voluntary. So if you simply ask the driver up front, are you willing to take a breath or blood test, instead of telling them that they have to do so, it's very likely that such consent would be deemed voluntary and the results of any test would be admissible, even if the implied consent admonition wasn't given. If the driver then declines to freely consent, then you need to administer the full DS-367. But you need to modify some of the consequences for the refusal in order to comply with the Birchfield decision. And we're going to go over that in a minute. If the driver still refuses to consent and you want to obtain a blood test, you need to get a search warrant at that point.
Now, in asking for voluntary consent up front, do the officers have to tell the driver that he can refuse consent?
Now, although it would help show that consent was voluntary, it's not required in order to prove consent was voluntary. And I know this seems to contradict what I said earlier, but here's the difference. While telling someone the consequences of refusing to give a chemical sample lets them know that they could refuse, it isn't the exact same thing as telling them directly, you have the right to refuse to consent. You do not have to tell the suspect you have the right to refuse to consent in order to have voluntary consent. If you want to ask for consent without telling a suspect the consequences of refusal, your request just needs to be phrased so that it is crystal clear that they are not required to give a chemical sample. So ask it like, would you be willing to give me a blood or breath sample? You cannot say you must or you have to give me a blood or breath sample.
Jim, you said the full admonition should be given if the person refuses initially to provide a chemical test, but that it needed to be modified to comply with the Birchfield decision. How should the admonition in the DS-367 be modified, and what is that full admonition?
Okay, so we're going to put a copy of the DS-367 up on the screen for you now. And there's two modifications that you're going to want to make to it. On page 2 of the DS-367, you need to modify line 4 of the chemical test admonition section on the top half of the page. The line reads, refusal or failure to complete a test may be used against you in court. Refusal or failure to complete a test will also result in a fine and imprisonment if this arrest results in a conviction of driving under the influence. You need to insert the word breath in the second sentence so that it reads, refusal or failure to complete a breath test will also result in a fine and imprisonment if this arrest results in a conviction of driving under the influence. Actually write the word breath on the form so that you know that you read it to the suspect. Now, the next modification is only necessary if you have to collect blood because you suspect the driver is under the influence of drugs. Go to the bottom half of page 2 of the DS-367 in the drug admonition blood and urine section. Again, in line 4, you will only read the first sentence. It reads, refusal or failure to complete a test may be used against you in court. The second sentence in line 4 that says refusal or failure to complete a test will also result in a fine and imprisonment if the arrest results in a conviction of driving under the influence should not be read. Draw a line through it so that you know that you did not read it to the suspect.
Well, Jim, that's good advice when it comes to DUI offenses. But is the advice any different when officers have lawfully arrested someone for being under the influence of drugs in violation of Health and Safety Code Section 11550?
There is no implied consent to search for people walking around while under the influence. There's no specific admonition necessary. A simple request of the person for a blood draw, unaccompanied by any threats or other coercive conduct, should permit the introduction of the results of the blood draw. Consent obtained after using the Health and Safety 11550 admonition card produced by the DA's office should also be valid.
Jim, what does that card say?
Well, the card says, you are being arrested for being under the influence of a controlled substance in violation of Section 11550 of the Health and Safety Code. I would like you to submit to a blood test to determine the presence of controlled substances in your body. If the test indicates there is no controlled substance in your body, you can use such evidence to demonstrate your innocence. If the test indicates the presence of a controlled substance in your body, such evidence can be used against you in court. If you refuse to submit to a blood test, the fact that you refused may be used against you in court as an indication of your consciousness of guilt. Do you understand what I've explained to you? Will you submit to a blood test?
Can we get a warrant for a blood draw if the person arrested for Section 11550 refuses consent?
No. Unfortunately, the statute which allows us to get a search warrant for a misdemeanor DUI does not apply to misdemeanor 11550s. But if they refuse after that admonition, we can use it to argue that they refused because they knew their blood would test positive for narcotics. It becomes another piece of evidence for us in the prosecution at that point.
All right. Any further thoughts?
If someone is 11550 while driving and it's impairing their ability to drive safely, then the DUI rules apply. Follow the same DUI rules that we just discussed, and if they refuse to give a blood sample, then you can get a search warrant for the blood just like you would for a DUI.
So Jim, bottom line here, is it fair to say that if you've arrested someone for driving under the influence, you can take one of two approaches to getting consent for a blood draw? You can start off by simply asking them for voluntary consent. Hey, would you be willing to give a blood or a breath test? Or alternatively, you could give some sort of truncated version of the admonition and then asking them the same thing. If the defendant refuses in either of those circumstances, then you need to read the full admonition. And if the defendant still refuses after that, if you want a blood draw, you're going to have to get a warrant.
Yes, as long as that truncated admonition advises them that if they refuse to give a chemical test, they could have a suspended license, and doesn't tell them that they're going to face a fine or additional custody time if they refuse to give a blood test. You can do that.
Thanks very much.
Thank you.